Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Hello, everyone. Welcome to Building Your Legacy in Southern Arizona with attorney Allison Manning. Allison is an estate planning attorney who helps individuals and families across Southern Arizona create clear, practical plans for the future. She works closely with clients on wills, trusts, powers of attorney, and long-term care planning with a focus on making sure those plans actually work when they're needed. I'm Sean O'Connor, and today I'm talking to Allison about what happens after someone passes away when there's a trust in place and how trust administration works in Arizona. Allison, how are you?
Hi, Sean. I'm well. How are you doing today?
I'm doing pretty well. As we speak, it's Friday, and that's never a bad thing.
Well, thanks for having me.
You bet. Let's talk about, trust administration. There's always some jargon. What is trust administration and how does it differ from probate in Arizona?
Yeah, it's a great question that a lot of people have because they want to know what's the benefit of having a trust, what's the difference. If there's still work to be done when you have your assets in a trust. It's is just done on the timetable of the trustee, and it gets to be done privately. So nobody gets to find out the information unless they're entitled to know it. So in a probate, we have to marshal the assets and pay the creditors before we can distribute money to the heirs. But we file a lot of documents. So anybody who wants to know information or wants to hold up the process is able to do that pretty easily by just looking into the court record. With the trust administration, we have instructions that are given to the trustee on what they're supposed to do with the money. We still have to deal with settling out any types of debts and creditors. We have to secure assets and get control over those. But we can do that in a private manner, and we can do it pretty efficiently as long as assets were titled in the name of the trust and there's all the beneficiaries are cooperating with the terms of the trust. Then things can be administered on the timetable of the trustee.
You mentioned timetable. Walk me through this. If there's a trust in place and someone passes away, what's the first thing that happens?
So when a trust is in place, you have to, most trusts, let me just back up a little, most trusts are grantor trusts that many of my clients are dealing with, meaning that those trusts use the social security number of the trustor, the one who created it. So one of the first things that a trustee needs to do is accept their position as the successor trustee. They need to get a tax ID number for that trust in order to continue on with managing the assets in the trust's name. There are some notices that need to go out in a timely manner out to beneficiaries who are qualified beneficiaries, and some notices to creditors as well. The first thing I would say that people should do is contact an attorney to make sure that they understand the terms of the trust and the responsibility and their duties that they have, the obligations they have to the beneficiaries in the trust.
I see. So who is the person responsible for administering a trust after someone passes away? Is that sort of written in advance?
If the trust is written correctly, then it should be written in advance who the trustee is. So the position is the trustee. The trustee is the one that has the fiduciary obligation for administering the trust. They are the ones that have the authority to get on accounts and deal with creditors, deal with the IRS, and also they have an obligation to the beneficiaries.
So, trustee is the person who administers the trust, and there's a job description that goes with that, and you just mentioned a couple of specific things. I'm curious if can you paint that picture? What's if I'm the trustee, what can I expect to have to handle when I administer a trust?
Yeah, so a trustee is in a fiduciary position. A trustee, the steps and things that they're going to need to do is again secure the assets, meaning if there's a house that's in the name of the trust, they're going to want to make sure that the property itself is secured. Or brokerage accounts, they're going to want to make sure that the new tax ID number for the trust is given to the custodian of where that asset is at. They have an obligation to secure those assets. They have an obligation to pay out any debts that are valid debts of the claim of the estate of the trust. And they also have an obligation to the beneficiaries to treat them fairly and to deal with them in a manner of, a good communication, and also making sure that they get the most for the trust estate as they can if they're liquidating assets. They have an obligation to follow what is set forth in the trust, and if there's any ambiguities, to clarify those and resolve any conflicts.
You mentioned a moment ago making sure that assets are included in the trust. I'm curious what kinds of assets are usually held in trust and handled through trust administration. I'm assuming that means certain assets aren't.
That's a great question. The assets that are typically held in the trust are, as I was saying, real property. So possibly your primary residence, and if you have multiple residents, and they can be properties in different states. They're not always just in the state where the trustor lived. You would have a brokerage account in the trust, possibly your savings, maybe checkings account. Sometimes we have vehicles in the trust. Sometimes we have them out of the trust. Assets that you would not typically see in the trust would be things like the IRA, though that's a retirement account or 401k, any kind of qualified account is going to be in the name of the decedent themselves because of the type of asset it is. Now, the beneficiary could be the trust, and so that it would pass through the trust before it goes out to the beneficiaries, but those types of assets we're going to leave outside of the trust while the trustor is alive.
I see. And so talk about debt, say like debts, taxes, expenses. How are those handled during trust admin?
So the trustee is going to get put first a notice into the paper for unknown creditors, so they don't have to, but I do recommend it because in Arizona, that would cut the timeline for unknown creditors to make a claim from 2 years down to 4 months. And then known creditors.
So sorry to interrupt you. So if
Yeah.
I don't have to put a notice in the paper, but if I do, it limits, it's a potential creditor only has 4 months versus, what did you say, 4 years?
2 years. So that's correct.
No.
So it's a huge recommended benefit for a trustee to do, especially if they're stepping in without knowing much of the creditor situation of the trustor. This way, again, medical bills, things come in late sometimes, and you can't really move forward with administering an estate if you have this unknown debt out there that's coming in later on after you're wanting to distribute money. So publishing a notice to creditors in the paper allows the trustee to cut the timeline down to 4 months from 2 years. And then the trustee must give actual notice to known creditors. So if they knew that of this creditor because they received bills in the mail, the trustee has to actually give them notice to submit a claim. And if they reference the Arizona statute that it handles, that deals with this, they can actually, again, enforce that timeline that they must submit a claim within 2 months or the end of that unknown creditor period, whichever's longer. If they don't submit a claim, then their claim can be barred. And again, it just allows for the efficiency in being able to move forward with administering an estate, not having to leave things open for years.
I see. Yeah, it's a big difference. How long, I mean, in your experience, how long does trust administration usually take in Arizona?
Yeah, it varies. It's a really good question as far as it's very common. People always want to know how long is this going to take? And my great lawyer answer is it depends. It depends because it really, what are the assets that we're dealing with? If we have to sell a house, that might take a little bit longer based on the real estate market. If we have a business in the trust, do we have to sell the business? And that, again, might take some time. If we have a brokerage account, we can liquidate things fairly quickly with that, get that notice period, which would get us down to at least that 4 month at the minimum. And we do need to deal with filing taxes. That's another one of those, to your previous question about debts that we have to deal with. We have to file taxes. So sometimes it depends on the time of year. If we're not at tax season, that might delay distributions as well until we can get all of the 1099s in for the decedent and file their final tax returns.
No, that makes sense. That makes sense. Are there other, like, assuming, the house is in order, so to speak, and things have been done, I'll say, properly. Are there other things that tend to create problems that you've seen, that just will delay trust administration?
So most of the delays that we see in administration happen to be when there is either a poorly drafted document. So there's a lot of confusion or ambiguity, which creates conflict within beneficiaries. There's also times when we have the other delays are when there's a creditor, and we're having to resolve this dispute with the creditor, showing that money's actually not owed or that they have a wrong amount, and we're needing to resolve that before we distribute out the money. But the other thing is not having assets in the name of the trust. That can cause a lot of delays, and not having clear beneficiaries as well. So again, having your estate in order ahead of time, as you were saying, having the house in order, that will help for a smooth administration. So many people will have documents, but they're not clear. I had a beneficiary who left a certain asset and they specified it by color, and then they said that my son gave me, I want it to go back to my son, this red item to my son. But the son gave the blue item, not the red item. And so it created a lot of confusion, because which one did she want the son to get? And so those kind of things are important to be clarified prior to the death, and that will help for a smooth administration.
Yeah. Did he give me the blue house or the red house?
Right.
It's
Exactly.
hard to remember that stuff. He was so generous.
Yep.
Follow-up question to the public notice. So if for whatever reason they opt to not file a public notice in the newspaper, does that mean that there's just no way the estate can be settled inside of that 2-year window? Or is it gets settled, but that something could come back and mess everything up?
Yes and yes. So it also depends on the trustee's comfort in settling the distribution. If the trustee distributes the assets and doesn't deal with that creditor period, so distributes assets prior to that 2-year creditor period, they can be personally liable if they can't get the beneficiaries to give them back money and pay the debt if it's a valid debt. So oftentimes, again, if they're choosing not to do the publication to creditors, oftentimes what I would recommend is holding back enough money in a reserve account before you distribute out. I just usually would recommend dealing with that notice to creditors and in the paper and not have to worry about it. I don't want my trustee to hold any extra liability that can be personally on them if it comes back on them. So in this situation, if we distributed out money early and there's no money there to pay a debt and it's a valid debt, that trustee could breach his duty to that creditor and having to settle that debt, and they have to come up with money and pay it.
Got it. That's good. Thanks for the extra detail. I'm looking at, as usual, coming up against time, which is fine. I want to ask you one more question about when, at what point does it make sense for a trustee to get the attorney involved?
The trustee should get the attorney involved as soon as they are accepting their position as trustee. And also when things change. So let's say they accept their position as trustee prior to the trustor's death, they should talk to the attorney at that death. Things change. Reporting requirements are important to meet. Filing those notice to creditors, giving notice to qualified beneficiaries, determining valid claims to creditors. All of those things are they're handled much better. It's much smoother transaction if it's handled from the beginning. So I would recommend talk to the attorney as soon as you become the trustee so that you know your obligations, that you don't take on personal liability, and that you can have a smooth trust administration that's efficient and effective for all.
Got it. I could be made a trustee years before the person passes, right?
You can be, absolutely. So if
I may be aware that, okay, hey, Sean, we want you to be the trustee on this. And so at that point, I want to know, I'll talk to the attorney, what am I getting myself into? Okay, I see. And then time passes, and then, okay, grandpa passed, and now it's time for me to talk to the attorney again.
Absolutely. You'd want to talk at both those instances. When you accept your position as trustee, you'll want to get some legal advice. And also when circumstances change, beneficiaries change, that's when you're going to additionally want to get that legal advice.
Got it. Well, Allison, as always, thank you for getting into the weeds on this. Really interesting and helpful.
Thank you, Sean.
That's it for today's episode of Building Your Legacy in Southern Arizona with Allison Manning. Trust administration can feel like a lot to take on, especially during an already difficult time, but understanding the process can help make things more manageable for everyone involved. To learn more or get guidance specific to your situation, you can visit Allison's website at AllisonManningLaw.com. Thanks for listening. I'm Sean O'Connor. Don't forget to leave a review, share this episode with someone who you think might benefit from it. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.